Good afternoon, everybody, and thank you so much for joining me today for this Trust Overview in 2022 webinar. My name is Jen Ruffley, and I work at Ingamora, which is the biggest accountancy firm in Tauranga. And it's a pleasure today to see some familiar faces and some familiar names. And for those who are new here, welcome. I hope this webinar, the aim of this webinar is to give you a simplified-ish overview of what's been happening in 2021-2022 for trusts. I try and keep things as simple as possible. My philosophy is I hate jargon and I hate making things overly complicated for the sake of it. However, trusts in nature are complicated. So I will try my best to break things down as I go along. But of course, at the end, there will be time for questions. And also there will be time for a follow-up. So if you do have any questions after the event and you don't want to ask them at the end, then of course you can email, call, or get in touch. I believe there's a survey at the end of the webinar as well, so you can complete that. Okay, so let's get started. We're aiming to go for about 45 minutes and then have some questions at the end. So I'll try my best to keep to the time. All right, I'm just going to pull up some notes here as well. And the other thing I want to do is just make sure I'm recording because, of course, there are some individuals who will want to listen again, hopefully not, but listen again or listen after the event. Okay, we're all set up to go. So some of the topics we're going to go over today, and let me get this up here. There we go. So we're going to have a recap on the Trusts Act 2019, which came into effect, well, has been in effect just over a year and a quarter now, so came into effect Jan 2021. We're going to talk about some other matters which I just seem to get asked about again and again. And there's certainly some common misconceptions over some of these topics. And really the aim of today is just to bring a bit more clarity around those items. So we're going to be speaking about succession of trustees, your very important power of appointment, which is an extremely important topic, which again is very overlooked. So we'll go through that together. Reviewing your wills and EPOAs, your Memorandum of Wishes, and the differences between that and your estate planning documents. Winding up a trust, quite a hot topic over the last year or so with the new Trust Act. Advantages of the independent trustee. Some of you may be operating a structure that has just a single or you and your partner or your husband, wife as the trustees, and you may want to know about the advantages of the independent trustee. And then finally we have some updates from the IRD. Well, the IRD have been very busy over the last 12 months to 24 months. And of course, trusts globally have been on the radar, following Panama Papers, and of course, more recently, some other exposures that have been going on globally. And of course, anti-money laundering legislation is always at the forefront of the OECD's mind. And of course, that filters through to the countries. So we'll be going through that as well. And of course, time for some questions. Okay, so this is a bit of a quote from me. It's certainly not meant to be clever. It's meant to demonstrate how no two deeds or days are the same. And that really is just a true reflection of trust work and trusts by nature. They are all so different. They have been drafted at different periods of time, so at different periods of legislation, different reasons, different family relationships and matters. And of course, once we have a trust deed in front of us or a client approaches us, we do often have to sort of have a sit down and get a really good background, get some really good background details as to why the trust was established and what the needs of the client are going forward. It's certainly not a one stop shop. I don't know if that's the expression, but it's a case of really tailoring it to a client's needs. And of course, no 2 days are the same is so true, because we don't know what's around the corner. And trusts are really connected to us during our life and after our deaths, and do reflect a lot on our family situation. So that's what's meant by that. Certainly not something to be rushed through or overlooked. Trusts are very complicated and something that we need to treat with respect. So that's that. We have over 500 clients here at Ingamora, of which we offer independent trustee services to. We have 6 directors, and those 500 clients are split equally, or a little bit less than equally, between the 6 directors. And really my job as the trust manager is to guide the directors through legislation changes, risk. It's to be a liaison point for the clients. And of course, it's to also manage that day-to-day client portfolio expectation, which we absolutely love doing. And if you do have any requirements or questions on that front, we can get into that later. So I am quite a visual person, and I love a good picture or a structure chart to show me what's going on, rather than a bunch of words. That's probably just the way my brain works. We're all different, but I have drawn up this structure chart to give you a basic New Zealand typical trust structure. And I do apologize in advance that I've used my dogs' names as the clients. So right at the top here, we've got Otter Ruffley, who's the appointer. And Otter features all the way through the structure chart. So if you look at the left-hand side, she's also the settlor. She's a trustee, 2nd level down. And right at the bottom level, she's also a discretionary beneficiary alongside her puppies and their issue, which means their children and their children's children. Those puppies are discretionary and final beneficiaries. And we'll come on to what that means later. And we've got the SPCA New Zealand, obviously that's a registered charity, as a discretionary beneficiary. Otter's very concerned with animal welfare, so she wants to make sure those guys are taken care of when she dies. Not to be mistaken for how you would set that up in a will, but again, we can clarify that later. So Otter on the left has come along to the trustees, and she wants to settle assets on trust. Otter is very worried about her children, her young children, being spendthrifts if Otter suddenly were to lose incapacity or pass away. So she wants to trust Sushi Independent Trustee Services Limited, her long trusted friend who went off and established a trustee company alongside some other very high up level intelligent directors who sits alongside Sushi on the board. So Otter decided Sushi Independent Trustee Services Limited was a good idea to hold her assets on trust, on the Canine Trust. And I do apologize, that arrow coming from the settlor box into the Canine Trust should actually be going up to the trustees, because the settlor relinquishes that legal control upon the trustees. Now, of course, Otter also wears her trustee hat. So she is also a trustee. And I do also like to have a bit of a visual of a dog wearing lots of different party hats, and that gives you a bit of an indication as to all her different roles. So she's a trustee. She sits alongside Sushi. She's also the appointer, which means it's sort of like a supervisory role over the trustees. You can hold sort of different powers as an appointer. We can come on to that later, but really the main point and the main power that you would expect an appointer to hold is the power to hire and fire trustees, so appoint and remove trustees. And that does still, that means that the appointer still retains that control over the movement of the trustees. But of course, Otter is wearing a different hat as appointer to settlor. It is a separate relationship. So the trustees manage the trust fund on behalf of the beneficiaries. in accordance with the trust deed and the legislation of the country in which they're operating. Of course, here being New Zealand, so the Trust Act 2019. Before that was the Trustee Act 1956. And Otter has also remaining in there as a discretionary beneficiary. So during her lifetime, the trustees can make distributions of income and capital to her in accordance with the trust deed. They can also make distributions to Otter's puppies and to a registered charity being the SPCA New Zealand. Otter's puppies being final beneficiaries, a bit of a strange concept for me, final beneficiaries. Obviously, not obviously to you because you wouldn't know, but for me, I grew up in a small island called Jersey, which is also is a highly operating trust structure, trust culture like New Zealand. Has many domestic and foreign trusts there, but we didn't have a concept of final beneficiaries. However, over here we do. And it just really means who is left at the end for the trustees to distribute the funds to. So trusts have a duration period of maximum 125 years in New Zealand. And if there's anybody alive at the end of those 125 years, or if the trustees decide to bring that date forward, which they're permitted to do under the trust deed, and if there were capital or income in the trust fund, then the final beneficiaries would be the recipients of that, of those assets. However, the likeliness of there ever being actual funds left at the end of a trust life is very unlikely. The trustees will often distribute that income and capital to the discretionary beneficiaries before the trust is ended. Okay, so we've just had a quick look at a structure chart, and I think it really just gives a good context as to some of the roles that we'll talk about during this webinar and later on. So we have the Trust Act 2019, which governs our New Zealand trusts here in New Zealand. It took effect on the 30th of January 2021, and it applies to existing and future trusts. So it covers all trusts despite ones being established before the 30th of Jan. It also governs those. Why did they do this? Why didn't they just stick with the old legislation? Well, it was fairly old. Coming up to 70 years. And it just modernizes what we had before. It's not really changed anything a great deal, in my opinion, but it has made legislation easier to read, modernized it, and it's made it more accessible to clients and solicitors. And it does, for sure, ensure efficient trust administration in terms of making it more flexible and, of course, via the duties it implies on the trustees. We'll come to those in a minute, but it's certainly, for me, it's made clients pick up the trust deed again and have a good look through and see the terms and really sort of get up to speed with their files and what's going on. So it certainly pushed people in the right direction. And this holding trustees accountable matter, well, that's because there's a new obligation or there's a presumption for trustees to make disclosures of trust information to beneficiaries. Again, something that's been a seriously confused and questioned subject over the last 18 months, so we'll come on to that. I've just put down there 2 hot topics: beneficiary disclosure. Well, that certainly has been. We can come on to that. And the default duties of trustees. We can come on to those in a minute, but it really has reiterated how important a trustee role is and how much work goes into being a reputable trustee. Okay, so beneficiary disclosure. Have you disclosed to your beneficiaries? Do you know what it is? And if you haven't, do you need to start panicking? Well, I think the fact that if you haven't done it and you're sitting here learning about it is a great start. We are working on the basis that beneficiary disclosure should have been done in a 12-month time frame from the 1st of January 2021 to the apologies, to the 31st of January 2021 to the 31st of January 2022. So we are technically over the deadline now. There's no official deadline. There's certainly nowhere to register that information, but it really is just sort of an unspoken rule in the industry that it should have been done by then. However, if you haven't done it, be proactive and look at your trust records and get going with that. So to take a bit of a step back, Section 51 of the Trust Act introduced a presumption that basic trust information will be made available to all beneficiaries. Now that's all beneficiaries that you would find in your trust deed. So you need to dig out your trust deed, or your solicitor needs to do so, and find out who the beneficiaries are. Often you won't see them written down by name, so there's often a class. So it would often, just give an example, it could say the settlor and the settlor's children, or the settlor's grandchildren, or the settlor's partner, or you could see somebody in there by name. That is quite rare, but I have seen it before. And then you could get wider beneficial classes like brothers, sisters, nieces, nephews. And I've even seen some that said anybody who is related to the settlor by blood, or anybody who has ever lived with the settlor. So of course, we're getting into territory now where you would want to be sitting down with your solicitor or your independent trustee to look at reducing those beneficiaries down to the direct family unit. If you need any more information about that, you can get in touch. What is the basic trust information? Well, it's the fact that a person is a beneficiary of a trust. It's the name and contact details of the trustee, of all the trustees. It's the occurrence of and details of each time there is an appointment or removal of trustee. And finally, it's letting the beneficiary know that they have the right to request a copy of the trust terms or trust information. We'll come on to what that is in a minute. I would say that the majority of individuals who are beneficiaries of a trust in the direct family unit wouldn't be surprised that they were discretionary beneficiaries of that trust. So I think it's a bit of a twofold exercise. I think you first need to sit down and look at your trust deed. And you need to, if there are any beneficiaries that won't ultimately benefit from the trust fund, or you have no intention of making distributions during during that person's lifetime, then during the trust's lifetime, then I would be looking at removing those. Again, always take your advice from your solicitor, or you can speak to us about reviewing your trust deed. The second step would be to get in touch with those beneficiaries. And you can do that by email, letter, you can have a conversation with them. The only thing I would say about having a conversation is that it's not in writing, and there's no way that you can prove that information's been given to that beneficiary. So I would always recommend putting something down in writing. Now, a lot of people might be sitting back and thinking, oh my goodness, I don't want to inform my beneficiaries of my trust. Well, there may be some seriously good reasons why you wouldn't want to do that. And Section 53 does provide you with a list of reasons why you may not want to disclose this information. Now, it's not just a case of going, okay, I'm going to make one of those reasons fit as to why I don't want to, because I purely don't want that person finding out because I don't feel like disclosing. But if there are reasons such as it could cause issues in the family, that person may never end up benefiting from the trust, or the likelihood of them benefiting is extremely low. It could be confidentiality reasons, could be the person's age, the disclosure for beneficiary information for trust information is 18. So if they are under 18, you can either disclose to the guardian, or you can resolve to disclose, not to disclose until that beneficiary reaches the age of 18. So I can understand people's reservations, and of course, from speaking to hundreds of clients over the last 18 months, we have certainly had some concern from individuals about that. So there are certainly, it is a process, and there are certainly things you can do for disclosure that you are very concerned about in terms of beneficiaries' welfare. They could have drug problems, social issues, mental health problems, mental health issues. So seriously consider that with your solicitor or with your independent trustee before you go ahead and make the disclosure. But we are working on the basis that most of the direct family unit will know about the trust. They're very unlikely to be even bothered about receiving information of this nature. And the likelihood of them requesting further information, I expect, is probably extremely low. If they do want to request further information, Section 52 is a presumption that a trustee must, within a reasonable period of time, give a beneficiary or the representative of a beneficiary the trust information that that person has requested. What is the trust information? Well, it's regarding the terms of the trust, which is the trust deed, the administration of the trust, or the trust property. The only thing the trustees don't have to do is include reasons for trustees' decisions. So that is quite helpful there. However, I have seen in the over 500 trust clients we have, and for all of the ones we've done beneficiary disclosure for, I have seen 2 individuals that have come back and asked for more information due to very good reasons. So it could be that their parents who are trustees are elderly and they want to help with administering the trust, which of course is a completely valid reason, and the trustees are often, or most of the time, more than happy to give over information to children who want to, of course, help mum and dad out with the running. So again, the likeliness of that trust information being requested is very low. Of course, it can happen. So the disclosure in the first place is something that you really need to consider with your solicitor. So I'm not going to go over this in too much more detail, only really just to say that if you haven't done so, certainly start considering it and make the moves to go and see your solicitor or your independent trustee. This is just to give you a bit of a heads up as to what can happen if you don't disclose to any beneficiaries. You must apply to court for directions if there's no beneficiary to whom information can be given, or you've refused a request for information which is reasonable in the circumstances. The whole idea behind beneficiary disclosure is to make the trustees accountable. And of course, most of the time, the trustees are going to also be beneficiaries. We go back to our structure chart. We've got Otta Ruffley as a trustee, but we can also see her as a discretionary beneficiary. So by nature of her being a trustee, and by nature of her being a beneficiary, she is very aware of what's going on with the structure. She established it as the settlor, and she also holds the appointer powers. So she is a discretionary beneficiary to which she has been disclosed. She's disclosed to herself. So that's a tick. One beneficiary has already received the information. However, best practice within the industry is to also be disclosing to the next level. So the children or whomever it may be who are over 18. If you're not disclosing to those individuals, then use those reasons under Section 53 not to disclose. If you do need any more information about that, please let me know. Okay, so just another quick couple of slides on the Trust Act. Let's see how I am for time. Gosh, 23 minutes already. Okay, so mandatory duties. These are duties under the Trust Act, and they have been just a consolidation really of the duties under the Trustee Act 1956. But they've put them down into 5 duties which cannot be varied or negated under the trust document. So if you have a trust deed that is varying or negating one of these duties, then those amendments are invalid. So under the mandatory duties in the Trust Act, the trustees must know the terms of the trust. So if you're a trustee, now might be a time to be dusting off your trust deed and having a good look through and knowing those terms. It's not just a case of being aware who the trustees are and who the beneficiaries are. Trust deeds are complicated. They are all different. They have lots of interesting terms in them, which you probably have never been aware of until now, or unless you cast a good eye over it. We offer a trust review service. So we do we complete, it's sort of 3 or 4 pages, we complete a form and we go through your trust deed to find out who holds all of these powers. So who's the appointer, who's the trustee, who are the beneficiaries, and we go through all of these mandatory and default duties in your trust deed to see what the stance is on all of these. We also check if it's robust under the Trust Act. So is there any terms that could be modernized? There's a couple of other bits in there that we'll look for. So trustee indemnities, are there any protector terms, lots of different things that we can look for there. And that trust deed review just sort of sits nicely as a complement in your trust file. And it just means that you can get a quick sort of glance at, if you ever needed to know any questions in the future, you just can have a quick glance at that and get the answer quickly without sifting through 25 pages worth of trust deed. Anyway, so that's knowing your trust terms. Act in accordance with those terms, quite self-explanatory. Act honestly and in good faith. Act for the benefit of the beneficiaries or the trust's purpose. And exercise their powers for a proper purpose. So I think all relatively reasonable requests of a trustee, and something that you should be following if you have undertaken that duty. Default duties. So the Act has also created a range of duties that apply to trustees. And these duties can actually be excluded or varied in the trust documents. So they are a guidance and duties of the trustees under the Act, but they can be varied or negated in the trust deed. I won't go through all of those there, but just to give you some examples as to why you would want to vary those duties and what you would typically see in a trust deed. Let's pick one of those. So yeah, a good example is not to profit from their position or not to act for a reward. Well, most independent trustees will want to be paid for their services. Most independent trustees are highly skilled individuals who are guiding you through legislation changes, providing reviews, drafting, also providing you with up-to-date tax and financial changes, IRD, new requirements. So certainly something that you would want to be paid for. So you would vary the trustee to allow you to profit from that position because of course you'd be paid. Another example is investing prudently, the second one down. Well, some individuals may not want to invest prudently. They may be setting up the trust for purposes of owning a business or a share portfolio, total share portfolio, or an investment portfolio, which may have more aggressive investments in there, which of course aren't always guaranteed to make money. Wouldn't that be nice? So you couldn't always guarantee a prudent investment. That doesn't necessarily mean it's not going to be a very valuable investment to the trust, because of course those aggressive trades and investment portfolios can make a lot of money. Of course, they can also lose a lot of money. So what we would usually do, if depending on why the trust was set up, we would vary that invest prudently clause to remove it in its entirety. And we've usually put some clarification for trustees in there about how they can invest the trust funds as they wish. And the only one that I would say that you wouldn't want to vary under those duties is the last one, which is act unanimously. I think if you have more than one trustee, so if you have maybe mum and dad or husband and wife and an independent trustee, I would want those individuals to act unanimously together to make decisions, because you wouldn't want to be in a situation where one trustee can go off and make a decision without consulting the other individuals. I don't think that makes any sense. And of course, you would want to know what everybody else is up to and make sure that they're complying with the legislation and the terms of the trust. Okay, let's move on. So succession of trustees and power of appointment is something that we get asked about a lot. Now, it's good to remember that the trust will live beyond the settlor. So once that settlor puts money into the trust, their relationship really has relinquished. But of course, you'll often see that person coming on as a trustee of the trust. So despite a settlor passing away or becoming incapacitated, despite a trustee becoming incapacitated or dying, the trust will continue, providing it has trustees to run it. So you need to consider who will be running the trust after you die. You will want to obviously appoint, or for somebody to appoint, a successor after you die. But who does this? Well, it's usually the person who holds this power of appointment. Now, the power of appointment, just to remind you, is the hiring and firing of trustees. So of course, after you're incapacitated or after you pass away, you would want somebody to hold that power to appoint somebody to be trusted to run your trust fund after you die. Usually it will be the case that there will be an independent trustee already on as a trustee of your trust, and providing your trust deed allows there to be one trustee. And usually it's the case that if there's a independent trustee that's a corporate, it's allowable, but of course always check the terms of your trust deed. If that's the case, more often than not, you'll find that the trust can continue with just one independent trustee. However, that person may not be happy with that independent trustee. They may want to appoint another independent trustee to run that trust together with the other one, or they may want to remove that one in its entirety and replace it with another. So it's just really a consideration point now as to who is going to hold that power after you die. It's important to remember as well that after you pass away, the trust will likely, depending on your wishes, be wound up. But of course, there is a time lag period between this happening. So the trust isn't going to wind up immediately on your death. There could be a period of, months or even years before the trust assets are wound up and distributed to the beneficiaries. And that really is the beauty of a trust, in that there is no rush to sell properties, to liquidate investment portfolios. It really is just a case of the trustees considering what is the best for the beneficiaries at the time. And I do truly believe that the succession element of trusts is extremely useful for families who maybe have young children, or children with needs, or even adult beneficiaries with health issues or mental health issues. It just allows that ability for the trust to continue after you die. Just a few clarification points on here, because this is something that's often confused. So the person who holds that power to hire and fire trustees is not automatically appointed as a trustee. So they can appoint themselves, but my advice is to always get independent advice on that. At the time that they want to be appointing themselves as trustees, they should be getting legal advice. Depending on where they're situated globally, there are all sorts of tax implications for overseas power holders appointing themselves as a trustee. So just something to take care of there, something to bear in mind if you are appointing an individual overseas with your power of appointment. This person is usually appointed by separate deed, so it would form part of your trust documents, and it would just be a deed saying, I appoint this person to hold my power of appointment after my death or incapacity. Or you would put that information in your will, and that is carefully drafted by your solicitor, and they'll be able to advise you at the time that they can put that clause in. It's certainly a common clause, and solicitors are very used to it being in wills. Okay, hopefully that's clarified. Now, estate planning documents. So it follows on nicely from what we were talking about. Your will is a very separate arrangement to your trust. You need to think of it really as two completely separate bubbles. So your will deals with your personal estate, so your chattels, your furniture, jewelry, anything that's not held in the trust. It could be your car, it could be cash that you have in a bank account, KiwiSaver, it could be anything really, anything that doesn't form part of the trust fund, anything that's not owned by the trustees. So that's what your will deal with, and then your trust will deal with anything that's of course owned by the trustees. And we'll come on to the Memorandum of Wishes in a minute, which is how we deal with those assets held in your trust. Your enduring powers of attorney are also something that should be reviewed regularly. So your enduring powers of attorney are for property and welfare. And you more often than not would want to be appointing an individual family member who knows you extremely well and would act for your welfare and matters regarding your property. And that is from signing that power of attorney to when you become incapacitated. Or could be if you leave the country, etc. But those matters are something that you should go over carefully with your solicitor. And just a bit of a heads up, if you are looking at winding up your trust, it's important to review and update your will to reflect these changes. So your will more often than not, refer to the fact that you have a trust. And if you do have a trust structure in place, usually your solicitor would have drafted that will that all of your personal estate comes to your trust. It's now owned by your trust after you die, and then your trust documents deal with those assets afterwards. So of course, if you're winding up your trust, you will need to change the terms of your will. If you do update your will and any other personal documents, and we are still the trustee of your trust, it's always helpful to provide these to your independent trustee. Your estate planning documents and your trust documents do form part of the overall picture when you do eventually pass away. So of course, it is helpful to know and much easier for the family if we're aware of the entire picture. Okay, so Memorandum of Wishes, it's not your will. It's a document to guide current and future trustees regarding distribution of trust assets during and after your lifetime. So it usually comes in the form of a letter. It's addressed to the trustees from yourself, from the settlor, and it can be very general. So it can just say, my trust assets are split 50-50 when I die, and I want the trust to be wound up, 50-50 between my children, if there's 2 children, or split equally. Or it can be very specific. So it can have an age that you want your children to be. If you were to die, young, prematurely, you may want your children to reach the age of 25 or 35 before they receive these big lump sum distributions from the trustees. You could have instructions in there for the trustees on, distribution amounts. We do tend to avoid amounts. Percentages are a lot better, but we also certainly can take instructions in there in terms of charitable donations and any other specific instructions that you might have. You may wish for your children to only use funds to purchase a home or for education, health, welfare. So it's completely your call and something that's very personal to you. Your solicitor can draft your Memorandum of Wishes for you, so they can take those instructions and put them into writing for you. It's something that you can write yourself, and it's also something that we can offer a service through Ingamora for our trustee clients to go through those documents and write them for you too. These documents should be reviewed regularly, only because, of course, family situations change, your attitudes change, and your trust assets will also change. So yeah, certainly something that we'd like to review every 3 to 5 years with our clients. Winding up the trust, something that's been extremely popular to talk about since the Trust Act. And of course, under these new IRD requirements, we have had a few clients getting a little bit upset, and rightly so, feeling that they're just being constantly watched and prodded by the IRD, and now is the time to wind up. Well, yes and no. Winding up should be carefully considered with your independent trustee, your solicitor, your accountant, your family. I think it's really important to wind up a trust for the right reasons. So you want to be winding up for a trust that has no assets and liabilities. You probably want to wind up a trust that's costing more to run than you're actually getting benefit out of. But of course, always look at those things carefully. Very hot topic as well. Some clients may be eligible for a rest care home subsidy if your assets have been slowly gifted to the trust over a number of years. So I won't go into detail too much about gifting, but if your trust is quite old, there's more often than not, you will have done the slow gifting of $17,000 a year. You would have had a debt arrangement whereby, say, the value of your house would have been an outstanding debt between you as settlor and the trust. And then that debt is slowly forgiven over time, whereby the asset value reduces in your name and increases in the name of the trustees. And if you've done it this way, then you could be eligible for a rest care home subsidy. But the rules are constantly changing and extremely complicated. So if you do wish to know more on this, please contact us. We have had a number of successful applications in the past, so we are well versed on what to do with these, but it does take some analysis and some time to look through the trust records. Of course, a huge benefit if you do end up qualifying for that subsidy, given that, rest home fees can reach up to $50,000 a year. But of course, these will, slowly be changing over the years. Do you wind up the trust if you just have your family home? Something that we get asked all the time. Yes, it could be an idea. Again, just being very careful of this rest home subsidy idea, but if you find that you didn't qualify for that subsidy, and you're finding it expensive to run your trust every year and it's just holding your family home, then now could be the time to wind up. But please consult with your solicitor and your accountant to make sure there's no tax or legal implications of this. Every situation is different, so it will take a bit of analysis. Winding up the trust is a process. You did relinquish legal control to those assets that many years ago, and of course all of that needs to be wound up. So assets and liabilities will need to be distributed. The relevant documents, deeds, trustee resolutions, conveyancing items and matters need to be considered with your solicitor, so please carefully look through that with them. Okay, I'm just going to check the time and how we're doing. I hope everybody's okay and still with us. Gosh, we have gone so fast. Okay, so advantages of the professional independent trustee quickly. Let me just flick my notes here. Maybe everybody can have a nice sip of tea. Okay. Managing a trust these days can be cumbersome. There's a lot of new compliance, there's new reporting requirements. The anti-money laundering legislation is just getting stricter and stricter as time goes on, understandably. So it can be a bit of a headache to be managing the trust on your own as a trustee. I think you will find in most cases as well, where you do have a trust structure that is set up for creditor protection or relationship property matters. If you don't have an independent trustee, your trust may not protect you, it may not protect your assets as you may expect. And I'm a true believer in that you must show that you really have relinquished legal control of that asset and ownership of that asset. And really, without an independent trustee, whether it be a third party, so it could be a relative or a friend, or it could be an independent trustee who is a professional. Without that other individual having to make decisions with you, you could really question, have you actually lost, have you really relinquished legal ownership of those assets? I would say the answer is probably no. Does it matter? Well, no, not at the moment, but what if it was to ever be challenged in court? I think it would be a different matter. Having an independent trustee really does demonstrate ownership of the trust assets have truly been relinquished. So it's just something to think about there. We do offer independent professional trustee services here at Ingamora. We do have some strict credentials as to what we expect if we're an independent trustee, and those are to produce the trust's annual accounts and tax documents, and that is purely from an oversight point of view. So if we're trustee, if we're preparing the accounts, we know what the activities are of the trust and the ownership of the assets, the comings and goings, etc. We ask that we have an annual meeting or a bi-annual meeting, depending on what the trust owns. So once every 2 years, or once every year, ideally. That can be in person, on a phone call, on a Zoom, on a Teams, on a Skype. And that's just to really catch up on an annual basis as to what's going on with the trust. And of course, any changes in family situation or any changes to your wishes. And we also ask to be a signatory on the trust bank account. If you don't have a trust bank account open, I would highly recommend you go and do one. Again, it just demonstrates that those assets are independent of you. If you have a trust established and you're still running the trust assets through your own bank account, then I would say the trust certainly is not set up in a way that is going to be beneficial and protecting your trust assets. So we would ask that we're a signatory on the bank account. And of course, this isn't a requirement to come and walk up to our offices every time you want to go and buy lunch, but it's a case of taking a sort of supervisory role on the account. So if there is any borrowings going on against the trust assets, then we would need to sign off on those, etc. It's not a day-to-day signatory on the accounts. Okay. So we're getting on to the new IRD requirements now and the new rules under these. I'm just going to take a quick drink, preparing myself for this. Okay, so it's twofold. So the first part is these new deemed settler rules, and then the second part is the new IRD reporting requirements. So I'll try and keep this nice and bright and breezy. Of course, this is not tax or financial advice. It's merely an overview of what's going on. If you do need to speak to your accountant in more detail about this, please pick up the phone or email your account manager here at Ingamora or elsewhere. And if you don't currently have us engaged as your account manager and want to speak to somebody about these rules, then again, please pick up the phone to either me or somebody at Ingamora who I can refer you on to. Okay, so the old definition of settlor is somebody who settles funds onto a trust. Relatively simple, but these rules have now changed. And a settlor will now include a beneficiary who is owed by the trust more than $25,000 at the end of the income year. This is unless interest is charged at the prescribed rate, i.e. if fair interest is charged, the beneficiary has not provided value to the trust. Probably sounds a little bit like gobbledygook, but it essentially means that if you have a beneficiary current account and the trustees are commonly making distributions to you, but you're not actually drawing that cash out, so it's just being left as a balance on the books, you are essentially giving an interest-free loan to the trust. So it does form a position whereby they're seeing you as a settlor because you're essentially providing an asset, by way of an interest-free loan, or an advantage to the trust, I should say. So why do we care about this? Does it matter? Why do we care if a beneficiary is deemed a settlor? Well, a couple of reasons. First one, it widens association for the purposes of the land taxing provisions, not something that would apply to many, but anyway, just something to bear in mind. Trustee income can be included in the family scheme income and working for families tax credits calculation if the claimant is deemed as a settlor. So that is something that's extremely important and could have an impact on many individuals. So certainly something to look at. It's also considered income in determining student loan repayment amounts. Again, something important to bear in mind. And settlors can be liable as agent for unpaid tax, income tax of the trust, where there is no New Zealand tax resident trustees. So, you know, it could be the case for overseas beneficiaries. If mum and dad were to pass away and no New Zealand tax resident trustees are appointed, and they appoint themselves, say, for example, going back to that whole overseas settlor, overseas power holder, don't appoint yourself. You know, there could be some liability for the unpaid tax income if you are deemed as a settlor. That being said, don't just default to charging interest to mitigate a beneficiary becoming an accidental settlor. Take advice from your accountant. I have seen some weird and wonderful things being done by some of our client managers here because there are sort of caveats and rules to this. So please go and speak to them first before just charging interest, which I'm sure you will. New IRD reporting requirements. Okay, so from the 1st of April 2022, trusts are required to provide more information on their annual returns for the 2022 tax year onwards. Huge shock horror. The IRD want more information. Well, what do they want? They want more information on the financial position of the trust, on the settlements, on who the settlors are, the beneficiaries, and the power holders of the trust. So most of this information will form part of the trust's tax return, but they are actually introducing a separate form whereby they're asking for more information on who holds these powers. Now, going back to our structure chart, I think right at the top, Otter held these powers of appointment, which is the hiring and firing of trustees. The IRD have actually gone a bit further and also want to know who holds the power to vary the trustee, who holds the power to add and remove beneficiaries of the trust. Now, you'll find that often this is the same person, so it's usually the settlor. And after the settlor dies, it's more often not the trustees. But there are all sorts of different, like I said in that quote, no two trustees are the same. There are all sorts of exceptions to that rule whereby it's a combination of different people. It's complete different third parties. It could be a protector. So please, 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 once we start requesting that information from you, please send us a copy of your trust deed and we'll be able to find out that information for you. Or please give us the contact details of your solicitor so we can ask them, or of course, we can ask you to ask them, whatever works out best for you. And it's not just a case of providing a name. Unfortunately, they want date of birth, tax jurisdiction, IRD number, the date that person came into appointment, and the date that person ceased to have the appointment if it's relevant. So it's certainly going to be an interesting year in terms of information gathering for the IRD. This is really for a couple of reasons. There'll be information gathering for anti-money laundering legislation. There's a lot of pressure from the OECD at the moment for jurisdictions to be complying with those rules. We, as a whole, New Zealand is viewed as moderately okay in terms of our trust position globally, but there will be more things to consider in the future, such as, you know, will they be bringing back, will they be introducing a public trust register and those sort of things. So we just need to do what we can at the moment and provide them with as much information as is reasonable. I think there's always got to be of managing expectations. But if you do have any confusion on that, and if there are questions coming at you in the future that you're unsure of in terms of what to provide, please contact me or your client manager, who is certainly more than happy to clarify on those. And just a little picture of my two doggies. That's Sushi on the left and Otter on the right. I do hope that you found this interesting and helpful. I certainly hope it wasn't too wordy and complicated. I'm just looking at my clock and I can't believe it's been 55 minutes already that I've been talking for. We do have a couple of questions, which I'm going to go through in a second, but those are my contact details there. If you do want to contact me, please email or call. More than happy to hear from you. I believe that there is a short survey that comes up as well at the end of this webinar, so please, if you can, answer that. And there are some inquiries as to if you do require any services after. Okay, so I'm just having a look at some of the questions here. Let me just see. Excuse me for a moment. I'm just seeing how I can grab these up. Okay, so somebody asks, is the $25,000 for beneficiary accounts over the lifetime of the trust, or is it during any 1 year? So this is referring to the $25,000 and over being a deemed settlor if you're not charging interest. And that is over the lifetime of the trust, not in any 1 year. So it's an accumulative amount for the beneficiary current accounts over that time. So I hope that answers that question. Somebody asks, will the link be available for review after the webinar? Yes, absolutely. We will send that out to clients who didn't get a chance to dial in, and of course anybody who wants to listen again, not a problem. And finally, someone else has asked about overseas beneficiaries. So does Australia have a different jurisdiction and rule-wise for resident beneficiaries in Australia, and does this affect disclosure? Sorry, I was just trying to reword the question a little bit there to be a bit more helpful for me in my head. But so if a beneficiary is resident overseas, then they still form part of the disclosure requirements where the trust was set up. So of course, today we're talking about New Zealand trusts, and despite them being overseas, they would still need to have that disclosure. So even if they live in the UK or Australia or Antarctica, they would still need to have that disclosure if they're going to form part of that disclosure under Section 51. And if you have reviewed the correct reasons as to why not to disclose under 53. I hope that's not too wordy, but if you do need any help on that, please let me know. Okay, I think that's it for everybody. If you do have any more questions, please contact me, and I hope that everybody has a fantastic day and hope to see you all soon. Thanks very much. Bye-bye.